Hi there, welcome to Employment Hour in 30. I'm John Scholes, he's Lior Samfiru. If this is the first time you're catching our show, welcome. And this is all about employment law, employment rights, and how to navigate that place you call work and spend most of your time. If you've been here before and seen our show, well, come on in, the water's warm. We're here for the next half hour to get your learn on and teach you a lot about the workplace and things that you have to, pylons you have to go around in the workplace as you go through your working career. 1-855-821-5900, help@employmentlawyer.ca. You want to reach out, we'll get to emails. A lot of phone calls from our radio show, which we've been doing for seven and a half years now. So busy show, that, and the Severance Pay Calculator. And this is very interesting as well. The topic today, Lior, and I know you saw this already, everything you need to know about severance pay. This one is huge, so stick around for it. But as we like to carry on and begin the show with a week that was something that's happened across your desk in the firm this week. What's going on, pal?
You know, I am very privileged in my job because I get to help people. I get to help people in difficult situations with important things. I help people with their workplace problems, and I'm very fortunate to do that, and I like doing that. And I'm glad that we have this forum here on this show to talk to people and educate everyone. So if you haven't seen the show before, you haven't heard us on the radio before, well, you're going to hopefully learn a lot about your rights. It's about your job, what you're entitled to, what the law does for you when it comes to your workplace rights. So don't hesitate to ever call with questions, to email with questions. I like doing it. I want to do it. And hopefully through this show and our other mediums, we'll help educate everyone about their workplace rights. And to start us off, to see the types of issues that I may have to deal with on a regular basis, issues that you may face sometimes in the workplace, let me tell you about the situation that came across my desk. I spoke with a gentleman who had worked for a company for only about 2 or 2.5 years, so not very long. And, a reasonably senior position. He was in charge of a sales team. Right. Unfortunately, things were not going as well as I guess his employer wanted. And about 3 months ago, they put him on a performance improvement plan. And they set some goals. They said, the team is not achieving the things we want, your team, your department. So here's some goals that we're going to achieve, and you need to meet those targets, meet those goals. And, he agreed that it's not going as well. He agreed to do his best to meet those targets. Sure. Well, fast forward 3 months or 4 months later, nothing has really changed. In fact, I think things have taken a bit of a further step back, despite everyone's efforts. So he gets called into a meeting on a Friday, and you know what Friday meetings mean. Yeah. And he said, it's not working out. We've put you on this performance improvement plan. Things have not changed. We've done what we can. We're going to let you go. So far, okay, except they're saying, that's a termination for cause because of the fact that we put you on a performance improvement plan. And they're saying, because it's a termination for cause, no severance. Of course. So he calls me, obviously very upset. He had never been unemployed in his life before. He's always kind of moved from position to position, and very concerned. What does this mean? Am I owed compensation? Is this right? So the answer is simple. It's not a termination for cause. Now, he was put on a performance improvement plan, and it was legitimate. But the fact that he couldn't meet those targets doesn't mean that it's cause. This is not a situation where he's slacking off, where he's purposely trying to do a bad job or to hurt his employer. He's doing the best he can with the skills, the resources that he has at his disposal. So that's not cause. For a company to terminate for cause, they really have to show that what the employee did is so bad that it's impossible to continue employing him. It's a very high standard. It's not enough. And this is the key. It's not enough to put someone on a performance improvement plan and then say, hey, you didn't meet the targets, you're out of here. That doesn't work that way, despite being on a performance improvement plan. Therefore, John, he is owed severance. And after 2.5 years, again, senior position, he's owed as much as 6 months' pay. 6 months' pay. So he was wrongfully dismissed. And I wanted to bring this up here because, again, reminder, you may have done something wrong, not enough to be cause. You may be put on a performance improvement plan, not enough to be cause if you don't necessarily improve. For you to be terminated for cause, the company has to show more than that. They have to show that you've actually done something very bad. You've done it repeatedly, and that relationship cannot be salvaged. Very difficult, and in most cases, that's not what happens.
From an employer standpoint, can a performance improvement plan from the groundwork, can that be the groundwork to eventually let someone go for cause? They obviously pulled the trigger way too soon.
That's the key. It's a step in the process. Right. So after that, there could be another step. Maybe there's a warning. Maybe there's a second performance improvement plan. You need to be able to show that as the employer, you've done everything you can and that the employee is actually doing something wrong. Because you may just be setting unreasonable goals. You can't set unreasonable goals and then fire someone for not meeting the unreasonable goals. If the goals are very reasonable, the employee did something wrong, you've done everything you can, and you've documented, if you're the employer, maybe then you can consider a termination for cause. You can't jump steps in the queue. If you do that, that's going to be a wrongful dismissal.
EmploymentHourTV.ca is a resource to find where you can catch our radio show. And each week here we play a couple calls from the show, and we talk about them. Call number 1 right now.
My wife, she was working for a brokerage for 19 years in a clerical type position, and they told her that her job would be outsourced. For 19 years, they gave her 2 weeks for every year, which was basically 38 weeks. And she also found out that her job that was supposed to be outsourced, they called in a person that was retired to come and do her job. I don't know if she has any legal recourse, because I went on your website. She was underpaid about $20-something thousand.
Yeah.
Yeah, I was going to say it was the money. The money is the issue.
It is. So they told her they're outsourcing the position, and it turns out maybe they're not really. Well, unfortunately, as frustrating as that would be, it's stinky. It would make you upset. It would make me upset. Yeah. It's legal. You can still let someone go as long as severance is paid, even if you're not honest about the reason. So this is a question about severance. Now, this person, after 19 years, was offered 2 weeks' pay per year. And I bet you if you ask most people, they'd say, oh, that's fine.
Par for the course. Sounds right.
2 weeks' pay is kind of the standard. It's fair. You should accept. There's no issue. It's not even close. And this is the key here. 2 weeks' pay per year of service is not even close to being your entitlements if you lose your job. It's a lot more than that. Remember, the factors are age, position, and length of employment. We'll talk more about severance in a second. But if this person and his wife want to see how much severance is owed, they go to severancepaycalculator.com. So let's take that information, let's plug it into the severancepaycalculator.com website, and let's see what we have here. So after 19 years of service, I picked an age. Let's say she's 56 years old in an administrative position, and she was offered 38 weeks pay. Again, 2 weeks per year of service. Well, as you can see on the screen, severancepaycalculator.com correctly assesses her as being owed 16 to 18 months pay. That's double what she was offered, and that's a difference at $25,000, $30,000 difference. Easy, not complicated. 2 weeks per year is not even close, and that's how easy it is to use the severancepaycalculator.com website. That's how easy it is to remember that it's not 2 weeks per year of service. It's not 1 week. It's not 3 weeks. It depends and it changes, and for most people, it's going to be a month per year, sometimes more than that. That's why you got to call me or go to severancepaycalculator.com.
Speaking about severance, a little later on the show, we will talk about everything you need to know about severance pay, but first, call number 2.
So I was working at a dealership for 4 years. I was poached by another dealership, and they told me that they wanted to give me a position in management. I went there. They switched it on me, and they said, oh, well, actually, we're going to make you this position. And then next thing you know, the position just turned out to be totally different from what I left another job for. It didn't end up working out, and I had to quit because they paid me half of what I was making before.
Wow. So inducement and then the wrong job to begin with.
The old bait and switch.
The bait and switch.
The bait and switch. So this is obviously wrong. They can't do that. If you're hired for a job and there's an agreement, whether it's a verbal agreement or in writing, that your job is X, Y, and Z, the company can't change that. They cannot say, well, instead of that, we decided you're going to better fit the other position. They don't have a right to do that. Just like if you get hired to be a sales manager, you can't come in from day one and say, I've decided I'm going to be the VP of sales, so thank you. Right? You cannot change your job that you're hired for. And believe it or not, the company cannot change the job that you're hired to do. So what does this mean? If the job is being changed, if he's now being put into a different job than the one he was hired for, that's a constructive dismissal. He says in his voicemail and in his call that he's going to quit. Well, yeah, he should quit, but in the eyes of the law, that's not a resignation. That's a termination. So even though he quits, he's going to be owed severance. So the question is going to become how much severance. One of the factors that's going to go into this situation, he says he was recruited away.
Right.
This is what we call inducement. So when the company recruits you from another position, you're not looking, you're securely employed, and they come to you and they convince you to leave, when they let you go, you may be owed enhanced severance. In fact, severance that recognizes your service with the previous company. So in this situation, he's going to be owed more severance than he would in a normal situations. I don't have all his particulars, but he's going to be owed much more than just if he had worked only for this company. He's going to get credit for previous service, and because of that, he really needs to call me. And there's an important lesson there. If your job changes, that could be a constructive dismissal. If you're recruited from another job and then let go, or if you're constructively dismissed, you're going to be owed enhanced severance. So important to get legal advice.
So if he came from another dealership and they induced him and he was a 15-year guy previous to leaving, that counts for his severance.
Well, think about it this way. Use your example. He worked there for 15 years. He was induced, came to a new company, and he works there for 2 months. And then he's dismissed or constructively dismissed. So the new company may say, you've only worked for us for 2 months. We probably don't owe you anything. Well, not so fast. In the eyes of the law, he could be a 15-year employee because he was working for the previous company and he was induced away from it. So even though after 2 months of employment, he could be owed 18 months of severance, even though he only worked for 2 months. Again, how many more reasons do I need to give to get some advice if you lose your job? There's a lot of factors that could impact how much you're owed, so don't walk away from your rights.
1-855-821-5900. Anytime to reach out or help@employmentlawyer.ca. I want to get to this. As we mentioned, this is a really important topic, and it's really the baseline why we do this show, and that is everything you need to know about severance pay, right?
And we talk a lot about a lot of things on this show, on our radio shows when it comes to employment, but the reason behind us starting the show all these years ago was to talk about severance, because there's so many misconceptions when it comes to severance, losing your job, what you're actually owed, who gets paid, how much you get paid. And every day I was talking to people that have signed severance offers, not knowing better, losing tens of thousands of dollars. So this is an important topic. It's literally where the money is, so you have to know.
So severance pay, termination pay, pay in lieu, I guess you hear that term. Is there a difference? It's all the same thing. We hear those terms all the time, right?
So I'm going to simplify this. I am going to simplify this without getting technical. If you're a lawyer, you may need to know the technical differences between termination pay, severance pay, pay in lieu of notice. Generally, though, it doesn't matter. It does not matter. When it comes to compensation that you're owed when you lose your job, I refer to it as severance. I can call it notice. I can call it pay in lieu, termination pay. It does not matter. In some situations, it matters. 99.7% of the time, it doesn't. So don't worry about it. Don't worry about what we call it. We're talking about compensation. We're talking about money. We're talking about what you're owed if you lose your job. That's all that matters. So that's why when I use the term severance, it's a general term. I can call it compensation. I can call it something else. So don't worry about it. Don't care about that difference. You shouldn't care about that difference. If you lose your job, you're owed compensation, you're owed severance. That's all that matters.
Everything you need to know about severance pay. I'm going to lob an easy one over the plate. This is like day one, employment law 101. How much severance should someone get if they lose their job?
And that is the key, right? That is the key. How much am I actually owed? And of course, the answer is it depends.
Yep.
Because there's no rule. And that's where the people get it wrong. People think, oh, there's a rule. It's a week per year of service. It's 2 weeks per year of service. It's 3 days. None of that matters. No, there's no rule. It's based on a number of factors. The key factors are your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior a position you have, the more you are owed. So no two cases are necessarily identical. So for me to tell you how much you're owed if you lose your job, I need to know a few things. How long you work, your age, length of your employment. Now, generally speaking, I can say that short service employees are treated disproportionately better than long service employees. So people with 5 years seniority or less are treated disproportionately better, but everyone is treated well. And that's why you call me. That's why you go to severancepaycalculator.com. For our discussion today, what I need you to know, what I need you to take away from this, that there's no rule of a week per year, 2 weeks per year. There's no rule at all. It's based on those factors.
I guess that's why when we've had many phone calls on the radio show in the past, people are like, well, our whole department got let go, and my buddy Jim, we've been there the same amount of time, he got X number of dollars more than I did, because it's individual.
Yeah, it is individual. So your friend Jim may get more or less than you, and that's fine. You can't necessarily compare unless you're the same age, same position, same length of employment. There's going to be differences.
Right.
Ultimately, your job as the employee that's been let go is to make sure that what you got is appropriate, regardless of what happened with anyone else. And just because everyone else got bad severance and they didn't know about it, doesn't mean that you should be getting bad severance as well. You know better because you're just watching us on the show. So don't let that happen to you.
Everything you need to know about severance pay. The next one is, can an employment agreement or a contract for that matter, can that limit how much severance you get?
So employers are getting wiser. What I mean by that is they understand, wait a second, we have to pay a lot of severance if we let someone go. So one way around that is to have a term in an employment agreement that limits your future severance. So an employer is able to have an employment agreement with an employee that significantly limits future severance to a fraction of what it would otherwise be. And many employers understand that and are starting to use that. 20 years ago, no one was using it. Now employers are using it. So when you sign an employment agreement, you have to be very careful. Is there something that down the road is going to cost you tens of thousands of dollars? Is there something that limits your future severance? If there is, you want to address it, negotiate it. And by the way, these things are negotiable. Ideally, you eliminate it altogether. Now, final point I'll make on this. Just because you signed an employment agreement 5 years ago when you started working and now you're let go, it does not mean that that employment agreement does actually limit your entitlements, even if it tries to do that. In many cases, 80% of cases, I would say, the agreement doesn't actually effectively limit the person's entitlements. They're just not drafted properly. So if you lost your job, even if you think, oh, I guess I have no choice because I signed this bad employment agreement a few years ago, that may not be the case. Call me before you accept anything. Don't assume that you're bound by it because you may not be, and you could be owed a lot more.
Having said that, how often do you see people offered less severance than they should be, not full severance?
John, if I see someone that's offered as much as they should be, I'm surprised. I go talk about that with my colleagues, and I say, can you believe it? I actually spoke with someone that was offered proper severance. It doesn't happen. 90% plus of people that I speak with, that frankly any employment lawyer speaks with, are offered a lot less than what they're owed. A lot less. I'm not talking, 6 weeks instead of 8 weeks. I'm talking about 6 weeks instead of 12 months. That's the type of difference that I often see. So it's very common. It happens all the time. Either the employer doesn't know any better or the employer hopes that the employee doesn't know any better.
Right? Yeah.
So one of the reasons we're here, one of the reasons we have this forum is to educate people so that if you're watching us and you lose your job, it doesn't happen to you.
Now people have gone to severancepaycalculator.com. They're a little wiser as to what they should be owed. Can the employer refuse to pay more even though they're supposed to?
There's still this misconception that the employer gets to decide how much severance you're owed or the employer gets to kind of set the rules. No, the law takes care of that. You don't get to decide how much severance you're owed, and your employer doesn't get to decide that. The law comes in and it says, okay, and based on these factors, you're owed this much. So your employer can't refuse to pay you. If I owe you $100 and I don't want to pay it, well, I'm going to have to. There's legal means to make me pay you that amount. Same thing with an employer. They can't refuse. If they refuse, if they're taking a silly position, well, the law is going to deal with that. So no, you're owed what the law says you should have. It's not up to the employer to change that.
Coming up, dropped from your employment while you're on a disability. We will cover that and lots more after we take a short break. 1-855-821-5900 and help at employmentlawyer.ca. Employment Hour in 30 continues. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30. John Scholes, Lior Samfiru, the part of the show where we talk about arguably the greatest tool since a Phillips screwdriver, and that would be the Severance Pay Calculator. Give me some details.
I'm not going to argue with that.
Right.
This show has been all about severance. So we touched on the severancepaycalculator.com, but again, for those that are still not sure what it is or they're just joining us now, severancepaycalculator.com, the tool that you can go to anytime, anywhere to find out how much you are owed. Whether you're staring at that severance letter or you're just curious or you're worried. The company is going through some changes. What happens if they drop the axe and you're out of a job? Go to severancepaycalculator.com to find out how much you are owed. It's the easiest, it's the fastest, it's completely free. Once you're there, you're going to answer 3 questions about your age, your position, and the length of your employment. You're going to hit the send button, and that's it. It's going to tell you how many months' pay you are owed. It can even calculate that in dollars if you want. It takes seconds. There's no risk. And I created that calculator to be a resource to everyone, to employees and employers, by the way, to find out what the law says severance is for them. So check it out right now. Make it a little party game where you compete with your friends to see who gets the most severance.
Oh, yeah.
And the winner gets something. SeverancePayCalculator.com.
That'll be minutes of fun, absolutely. There's an employer mode, as he said, absolutely free, and over 500,000 people have tried this thing. But we always give an example, the best way to show it off. So here we go. 62-year-old Stefan was in a management position, earning $90,000. That's good coin. After 14 years on the job, he was let go. He's out of there. The owner felt that his methods were outdated and ineffective. That's what he was told. Stefan was offered 1 week for every year worked. There you go. For a total of 14 weeks. Is that even close to being fair?
So this is obviously a real situation. We changed the names to protect the innocent, so to speak. But it's real. So let's talk about that. First of all, whether his employer is right that Stefan's methods are outdated, whether that's right or not, ultimately does not matter because they're allowed to let him go.
Sure.
They're allowed to let him go as long as they pay proper severance. He may be upset. He may say, what are you talking about? My methods are the best methods in the world. But irrespective of that, he can be let go. It's a question of severance. So SeverancePayCalculator.com. Let's plug his information into that SeverancePayCalculator.com site, and let's see how much he's actually owed. So he's in a middle management role. We can see on the screen. He's been there for 14 years, 62 years of age, as you said, making good coin at $90,000. Well, his employer offered him 14 weeks, except, guess what? You can see on the screen right now from SeverancePayCalculator.com, he's really owed 18 to 20 months' pay. 18 to 20 months' pay. That's over $100,000 in difference. Over $100,000. And
crazy.
Again, it's not like I've been sitting up all night looking for a really weird, crazy case. No, this is a common, run-of-the-mill situation. There's nothing unusual about this calculation that we saw right now. That's how easy it works. So Stefan looks at this, say, wait a second, they've offered me 14 weeks. It should have been 18 months. Yeah, no, that's not right. Yep. So that's why he knows to contact me. We can resolve it. It's not difficult, but it starts by going to SeverancePayCalculator.com.
After that, EmploymentHourTV.ca, great resource to find the radio show. Grab the podcast of the show as well. And from it, another phone call for this hour.
I've been on disability now for just over 2 years, and I received termination papers. First off, were they legally able to terminate me since I was on disability? The second part to that is I've been employed for 4 years prior to that. So there was 4 years where I was actually working and 2 years where I was on disability. But I would expect that I could go back to work in the coming months or within the year.
Released on disability.
Yeah, released on disability. So the first question I always have when someone calls me and they say, I'm off work, I'm sick, I'm on a disability leave, I've been let go. First question is, why? Do you know why you were let go? Is it a situation where the company has gone through a major restructuring? Did they shut down the office? Why were you let go? And the reason I want to know why is because what I'm trying to determine is, did the person get let go because they're on a disability leave? Because if they were, that's illegal. The company cannot do that. The company cannot let you go because you're on a disability leave, even if you've been off, in this case, over 2 years. It doesn't work that way. You can be off as long as you need to, as long as you have a medical reason and a doctor saying that you cannot work. So I would want to know, is he really let go because he's on a leave? Is that a human rights violation? If it is, there's human rights damages. If there isn't human rights damages, in other words, it's a legitimate termination. They shut down the office. He just happens to be on a disability leave. Of course, he's owed severance. The key, by the way, is that he worked for 4 years. He's been off on disability leave for 2 years. He's now a 6-year employee. So when it comes to calculating severance, of course, length of employment being one of the factors, he is owed severance as a 6-year employee. And that's important to remember. The time that you spend on a disability leave, even if it's years, it counts. It counts towards the length of your employment, and that could impact your severance. So was he let go because of his disability? If so, it's a human rights violation. Otherwise, it's a question of severance, and he's a 6-year employee.
Your employer just handed you a severance check over the table. Should you go and cash it with check in hand? We'll cover that after a short break. Lots more. Employment Hour 30 is on the way. Stick around.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
EmploymentHourTV.ca, that is the website. Go there, find out where you can catch the radio show, present and past. You'll find out a station where you can catch that. And we take phone calls from the show. We play them back. Here's the, third phone call for the day, or fourth? How's my math? We'll get to it right now, regardless.
I'm a healthcare professional at one of the hospitals. I'm 48. I've worked there for almost 25 years, regular part-time. And there's been some cutbacks this year, and there's been some talk about reducing my hours. Can they actually cut back my hours? I don't have to accept that, right?
Smart.
She's right. She does not have to accept that. And unless they're cutting back her hours but leaving her pay the same, in which case, hey, I want to work there as well.
No kidding.
If that's the case, if they in fact cut her hours and her pay, she doesn't have to accept that. As I said earlier, an employer cannot change the terms of employment, and reducing your pay, reducing her hours is the big one. You know, it's probably the most important term of employment.
Sure.
How many hours I work, how much do I get paid? So they can't do that. And if they do it anyway, she can, and I would say she should, treat that as a constructive dismissal. She can leave with severance. Now, she can try to convince them to back off and not to do it, but if they do it instead, or in any event, if they do it, she can treat that as a constructive dismissal, and she's owed severance. So let's call back on our friend, the severancepaycalculator.com site, and let's see how much she would be owed in a constructive dismissal situation. So she's in a healthcare role, 25 years of service, 48. She started there very young, and SeverancePayCalculator.com says, as you see on the website, she's owed anywhere from 18 to 24 months of severance. So that's what's at stake for her. Even if it's a situation where the company does not let her go, she is the one that's going to be leaving. She's the one that's going to be treating that change in hours as a termination, as a constructive dismissal. SeverancePayCalculator.com works just the same.
Place you can go as well, terminationquestions.com. Ask your questions about this show or any employment matters, and they get to answer by Lior, a member of his team as well. We'll get to one again. Terminationquestions.com is the place. Says, can I cash my notice of termination check, even if I still plan on pursuing a severance claim for wrongful dismissal?
So here's how severance letters and severance payment work in most cases. The company is going to say, we're going to pay you a certain amount anyway. Here's a check for that.
Sure.
And we're going to offer you something more than that. But to get that extra amount, you have to sign this document. So a company may pay you money, or may even deposit money into your account, and that's fine. You absolutely can cash that check.
Right then and there.
You can cash the check, take the money, spend the money. It's your money. The fact that you did that doesn't mean you're not owed more. It doesn't prevent you from pursuing your entitlements. So if the company pays you some money when you lose your job, you can take it. You can still pursue your entitlements. What you cannot do is you cannot sign something. You cannot sign what we call a release that says that by taking this, by signing here, you agree to give up your rights. As long as you haven't signed anything, you got paid. You can take that money. It's your money. You don't lose anything by taking that money, and you can still pursue your full entitlements.
And that's when they call you and make sure, which almost guaranteed that offer they're going to have her sign or him sign, it's not adequate.
John, I always say when you lose your job, you make two calls. Right. First call is you call your significant other, husband, wife, boyfriend, girlfriend, and then you call me, okay? Second call, you call me. In between, you want to go to SeverancePayCalculator.com, but otherwise you call me as soon as you have that letter, before you sign off on it, not after. The worst calls that I get is people calling me after they signed off on that severance letter. Bad situation. Don't do that. If you do that, unfortunately, I can't help you. The time to help to get help, the time for me to get your entitlements is after you're let go, before you sign off on anything.
Again, SeverancePayCalculator.com. One more time, the phone number 1-855-821-5900, and email as well. Very simple. It is quite simply help@employmentlawyer.ca. Hope you enjoyed the show. Come around again when we do this all over again and learn more about your job and severance and your employment.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.